Welcome to the Compliance Council on Command webinar series. Today's topic is qualified mortgages. I'm Jeff Anderson. I'm an attorney at Dickinson Law focused on working with community banks, particularly with regard to regulatory compliance. So the qualified mortgage rule is really part of the larger ability to repay rule codified in Reg Z in 1026.43. So today I'm going to focus on the qualified mortgage aspect of that rule, and then in subsequent webinars we'll talk about the ability to repay standard, and then weigh the risks and the differences between qualified mortgages and ability to repay loans. So to back up at a high level, what this new ability to repay qualified mortgage rule is, the text of the regulation says, a creditor must make a reasonable and good faith determination at or before consummation that the consumer has the ability to repay the loan. What that really means is this regulation has created a new cause of action for borrowers against you, the creditor. So now, if I'm your borrower, you make a loan to me and say after a year's time, I'm delinquent in payment, and you initiate foreclosure proceedings against me on my home. Now I can assert in that foreclosure as a partial defense and seeking to recoup certain finance charges, I can assert as a defense that you, the bank, did not consider my ability to repay when you made the loan. Now that may seem counterintuitive. As the borrower, I should have better knowledge of my ability to pay a loan than anyone in the transaction, but nonetheless, the regulation now imposes on you, the creditor, a requirement to make a good faith determination of that borrower's ability to repay. So now we have this new cause of action that can be brought against you, so a new risk in association with home mortgage lending. The regulation has given two primary ways to defend against that action. So two ways for you to comply with the rule and defend against those possible consumer causes of action. One is qualified mortgages, which we'll talk about today. Qualified mortgages, if you make a loan that meets the qualified mortgage criteria, you'll get safe harbor protection. So safe harbor is a relatively high legal protection where if you can prove that you made a qualified mortgage, you'll be absolutely have an absolute defense against any liability vis-a-vis the consumer. The other way we'll talk about on a subsequent webinar is the ability to repay standard, where you get a little bit of a lesser legal protection. You get that rebuttable presumption as opposed to the qualified mortgage safe harbor. The coverage of this rule is very broad, so it applies to all closed-end loans secured by a dwelling, with some exceptions I've enumerated on this slide. So this is in Regulation Z, so we're using that Reg Z language, dwelling, as opposed to the RESPA language, which uses federally related mortgages. So here we're closed-end loans secured by dwelling, so this does not apply to HELOCs, other explicit exemptions. It does not apply to timeshares, reverse mortgages, temporary loans or bridge loans with a term of 12 months or less, and the construction phase, if that phase is 12 months or less, of a construction to permanent loan if you structure the loan correctly. Those are the only exemptions from a product perspective. From an entity perspective, there's only one exemption, and that's for community development financial institutions, CDFIs. They're completely exempt from the qualified mortgage ability to repay rule. A CDFI institution is not going to have any potential liability. The consumer is not going to be able to bring this cause of action against a CDFI. So CDFIs, it's pretty limited. There aren't that many CDFIs right now, but given the exemption granted in this rule, I wouldn't be surprised if more and more banks in the coming years try to seek CDFI status. So it's a status that's granted by the Department of Treasury. It can be quite an application process. Essentially, there are a lot of criteria to be a CDFI, but you have to be in certain counties, certain underserved counties, or you have to be making certain percentages of loans to underserved communities. That's the only entity level exemption. So you hear about the small creditor exemption, and it is, and we'll talk about it today, but the small creditor exemption doesn't mean that you're exempt from this rule because you're a small creditor. As we get to that, you'll see it's really a loan-by-loan exemption. If you make a loan that meets that small creditor exemption, then you don't have to jump through as many hoops. But the small creditor exemption is not an across-the-board exemption to the ability to repay a qualified mortgage rule. Now, before we jump into the rule, I talked about that definition of dwelling, a common term used in Reg Z. This is nothing new. The definition of dwelling has been in Reg Z for years, but it's a question that often comes up, given the breadth of this rule and the importance of this rule, is, well, how do we know if a loan is secured by a dwelling? Well, here on this slide, I have the definition from the regulation of what a dwelling is. Where questions come up is, what about a mobile home? What about a boat? What about a trailer? Because the definition of dwelling in Reg Z is not limited to dwellings that are located on real property. It does not have to be attached to real property. It just has to be any dwelling. So a mobile home or a boat or trailer could be a dwelling if it's used as a residence. The regulation in the commentary doesn't give you much guidance beyond that about what makes something a dwelling. There's nothing in there that says it's a dwelling if it has a kitchen and a bathroom. There's nothing in there like that. So really, in determining if you're making motorhome or mobile home loans, determining whether it's a dwelling, I think you really have to rely on what the consumer tells you. So you can put in your application, put in your documentation, language that they have to check the box or write in that says, and do you intend to use this as a residence? Do you intend to use it as a dwelling? And I think that's really all you can do. I mean, in the end, if you make a loan on a boat, for example, and they said it was not a dwelling, you can't row out there and check on them overnight to see if they're truly using it as a dwelling. There's no expectation. I mean, regulators have a lot of expectations on you, but it hasn't gone that far yet. So I think you ask the question up front, and unless you have knowledge to the contrary, you rely on what that borrower tells you. Okay, so we talked about the qualified mortgage, ability to repay, two primary ways to defend against this new cause of action. There's another I'll talk about on another separate webinar, the non-standard to standard mortgage refinances. But today we're really going to focus on the QM. And there are really 4 ways under the qualified mortgage rule that you can get a qualified mortgage. You can have a small creditor exception QM. You can have an eligible loan QM. If you're a small creditor, you can make balloon loans in certain instances and still get that qualified mortgage safe harbor protection. And then you have what I call the standard track qualified mortgage. So those qualified mortgages that aren't small creditor or eligible loans. So this is the way I visualize the coverage of this rule. So when I'm working with a bank and going through their loan portfolio and discussing where their loans fit, I think of it this way. And if you can get one of the exemptions, small creditor or eligible loan, then you're most likely going to want to. So I think, first of all, overlay on top of your loan portfolio, do you have any that meet the small creditor exemption? And we'll break down and talk about these in more detail. But you start there. Okay, you have some loans that fit in that top bucket, but you have loans that don't meet that for various reasons. Perhaps you sell it within 3 years, for example. All right, well, that's not going to be able to be a small creditor qualified mortgage. Now go down and say, well, is it an eligible loan? Eligible loan are generally loans that are eligible to be purchased by Fannie or Freddie, okay? So do they fit there? All right, you might have some that you're selling to Fannie and Freddie, but you might have some that you're not, that you're still retaining in portfolio. Now you're down to the standard track qualified mortgages. So now you have 43% DTI, more convoluted underwriting requirements. You have loans, see if you can fit them there. If you have loans that fall outside of that, so for example, you may have some loans that you want to make, but that are above 43% debt to income ratio, now you're down to the ability to repay standard. So all of your loans you want to fit in this inverted pyramid. And you just, start and figure out where they're going to fit. So let's dive into that in a bit more detail. And I'm going to structure this presentation. I'm going to start and talk about the aspects of the qualified mortgage rule that apply generally. So these first slides I'll go through, these apply to qualified mortgages across the board. So to go back to this pyramid, what I'm going to talk about first are the requirements that apply whether you're a small creditor QM, an eligible loan QM, or a standard track qualified mortgage. These are going to apply regardless. So first of all, and the first kind of twist of complexity with this rule is I talked about you get a safe harbor with qualified mortgages, right? There's one exception to that, and that is if it's a higher priced mortgage. So the higher priced mortgages under 1026.35, where you have to escrow for them, those that meet that standard, the loans that are 1.5 over average prime offer rate or 3.5 for subordinate liens, those higher price loans you can't get a safe harbor for, okay? So if you have an HPML, it can still be a qualified mortgage, HPML, but you're only going to get a rebuttable presumption, all right? So that's one layer of complexity. Generally, HPMLs are only going to get a rebuttable presumption. Now, no good regulation would be complete without an extra layer of complexity. So one extra layer is they've given a bit of a break for small creditors on that. So I talked about your general higher price threshold is if the APR is 1.5 over the average prime offer rate for a first lien, okay? So for purposes of this rule only, if you're a small creditor, which we'll talk about, then you use 3.5 over the average prime offer rate on a first lien transaction. So that only applies here. So you're still going to have to escrow. All the other HPML rules are going to apply based on that normal 1.5 threshold that you're used to. But for purposes of figuring out what legal protection you have under the qualified mortgage rule, instead of 1.5 over APOR for a first lien, you're going to look at 3.5 if you're a small creditor. So what that means is they're giving a break to small creditors and saying, you small creditors, we're going to let you make some higher priced mortgages. So some that are between 1.5 to 3.5 over the average prime offer rate. Because you're a small creditor, when you make those, you can still get a safe harbor. If you're not a small creditor, then you're still stuck with everything over 1.5. You're only going to get a rebuttable presumption on. Okay, so the requirements that apply to all QMs, small creditor, eligible loans, standard track. First, you generally have to provide for regular periodic payments that are substantially equal. There are other certain product restrictions on QMs. You can't have negative amortization. You can't have interest-only loans. You can't have a term exceeding 30 years. And, of course, everybody's favorite topic, points and fees. You have to keep your points and fees under certain thresholds in the rules, which we'll go into in more detail. So this isn't to say you can't have interest-only loans. It's just you can't have an interest-only loan and expect it to be a qualified mortgage. So you can still have loans that have all of these features, but those are going to fall down to that ability to repay bucket at the bottom, because you have an interest-only loan. It's not going to be a small creditor. It's not going to be an eligible loan. It's not going to be a standard track qualified mortgage. You're down to ability to repay. So you can still make those loans, but you're not going to get the qualified mortgage safe harbor if you have those features. So let's talk about points and fees. So this is probably the most confusing portion of the rules, I think. If you just read through the regulation, This is so circuitous. It refers to the definition of finance charge. You have exceptions on top of exceptions on top of exemptions. It's very difficult to go through. So I'll try to break it down at a more granular, understandable level. So first of all, the threshold. The basic threshold for qualified mortgages, again, this is all of them, whether you have an exemption or not, is if it's over a $100,000 loan, points and fees can't exceed 3% of the total loan amount. For loan amounts that are under $100,000, basically there's tiers where you get a little bit more wiggle room because they've accounted for in the regulation that, you know, if you have a $10,000 loan, 3% of the total loan amount isn't going to give you that much room. So they give you 8% of the total loan amount. You get a little bit more room as you get to the smaller dollar amount. But the most general is 3% of the total loan amount for loans over $100,000. So what, you know, of course there's definitions to unpack there. What's the total loan amount? Total loan amount is essentially taking the amount financed and subtracting out certain of the points and fees that if they're rolled into the loan amount. So you would take the amount financed and you would subtract out any real estate related fees, you know, flood insurance, title insurance. You'd subtract out any upfront credit insurance that was paid and any prepayment penalties. Subtract those out. That's going to be your total loan amount. Your loan amount is just the amount reflected on the note. So to go back, your loan amount, what you're looking at for, you know, whether it's $100,000 over or less, that's just the amount of the note. The total loan amount that you're using to actually do the calculation, hopefully your computer system is doing that calculation, that amount is based on the amount financed with certain upfront paid points and fees subtracted out. So I have some slides here just for your use and your review about what's included in points and fees. So I've broken it down and laid out in summary form what's stated in the regulation. But I really want to move on and break it down at a level of what I see in banks commonly that gets included in points and fees. So again, this is just another slide that breaks down some of the regulatory language. But really I see 7 common things that get included in points and fees. This may not be an exhaustive list of 7. You may have some other items that are included. But these are really the most common things and the most impactful fees that add up and can get some community banks close to that 3% threshold. So the first is certain loan originator compensation. You have to include third-party loan originator compensation in points and fees. So that means your employees that are loan originators under the definition in Reg Z. It's a much broader definition now. That'll be a whole other webinar series. We'll talk about loan originator comp. But your employee loan originators, you can pay them. That doesn't get counted at all. That is completely irrelevant in the points and fees calculation. But if there's a third-party loan originator on a transaction, that third-party loan originator's compensation is going to get included in points and fees. The no double counting, what that's referring to is initially when this regulation came out, the way it read, you'd actually have to count that twice. But they went back and they've gone back and fixed a lot of things in the rules, and they've gone back and fixed that, and so there's no double counting. You only count that loan originator compensation once. The second item is upfront credit insurance. So when I say credit insurance, it includes credit insurance for which the creditor is the beneficiary. We're talking about debt cancellation, suspension insurance, any credit insurance that is up front will be included in points and fees. So we're not talking about upfront credit insurance for which the consumer or someone else is the beneficiary. This is credit insurance for which the bank is a beneficiary. It doesn't include any credit insurance that's just paid monthly after consummation. So you don't have to consider that for points and fees. It's just if they pay any credit insurance up front, at or before consummation, that gets rolled in to points and fees. Next is upfront PMI, private mortgage insurance. So again, after consummation, the most common PMI is just a monthly charge that happens post-consummation. That doesn't matter for points and fees purposes. The only thing that is included is if it's upfront PMI. And even then, there's only a fraction of that that will be included. So when we talk about upfront PMI, we're talking about there's two layers of upfront PMI that you can have. You can have non-refundable private mortgage insurance that's paid up front. That is all going to get included in points and fees if it's non-refundable. Okay? Then you have refundable PMI. So if it's refundable in a manner where if the borrower pays off the loan, then they get a refund for any portion of that PMI that they've already paid up front, then it will only get included in points and fees to the extent that it exceeds the FHA mortgage insurance percentages. So right now your FHA is borrower single pay refundable PMI under FHA is 1.75%. So upfront PMI, you look at, first of all, is it upfront? Is it before is it paid before consummation? Okay, if it is, then you look at, is it non-refundable? Okay, if it's non-refundable, it's included. If you have any that's refundable, now you're looking at, well, does it exceed that 1.75% of the loan amount? If it does, then you would include it to the extent that it exceeds that amount. Fourth is bona fide discount points. So you have to include certain percentages of bona fide discount points. What's a bona fide discount point? It's a buy down. So it's when a borrower pays a point up front in conjunction with getting a lower rate. So the rule's laid out in a complicated way where it excludes certain bona fide discount points. So the starting presumption is discount points are included in points and fees. But there are two exclusions. So you can exclude, and they're all based on a comparison to the APR against the average prime offer rate. So you can exclude up to 2 discount points if that zero rate, if the zero discount rate on the loan doesn't exceed the average prime offer rate by more than 1%. So what you do is you look at the APR on the loan, what it would be without the discount, without the points and fees, without the buy down. What's that rate? Okay, does that APR exceed the average prime offer rate by more than 1%? If it doesn't, then you can exclude up to 2 bona fide discount points. So you would only include in points and fees any discount points that are over 2. So if you had 3 discount points, you'd include 1. The second tier is you can exclude up to 1 bona fide discount point if the rate without the discount doesn't exceed the APOR by more than 2%. So these don't work together. You can't add them up. They're just 2 tiers that you go through. If your APR doesn't exceed the average prime offer rate by more than 1, you can exclude up to 2. If it's a bit higher than 1 but still doesn't exceed it by more than 2%, then you can exclude up to 1 bona fide discount point. The fifth is very broad. Any fee that's retained by the bank or the bank's affiliate. So anything that you're retaining that's not a pass-through third-party fee. It can be an origination fee, a closing fee, an underwriting fee. It can be a fee for services rendered if the bank is performing that service or if the bank's affiliate is performing that service. So this can be a very broad one for a lot of banks that may have a lot of affiliates. That definition of affiliate, they reference the Bank Holding Company Act definition. And in sum, the Bank Holding Company Act states that to be an affiliate, the bank has to be able to exert some control over that affiliate, over that entity. So if you're just a minority shareholder in some affiliate, less than 5% ownership, you're going to be presumed that entity is going to be presumed to not be your affiliate for purposes of this rule. If you have an affiliate that you own 51% of the ownership in, it's going to be presumed to be your affiliate. You should be able to exert control over that. If you're in between, say you're 25%, 35% control over an entity, then it just becomes a factual question. So in most instances, if you're under 51, if you're under 50, you should be outside of being an affiliate. But situations can arise where you can be under 51, of course, and still be able to exert control, be able to elect a majority of the board of directors, for example. So it becomes a bit of a factual inquiry. But the key point is an affiliate that you have control over. If it is, you're going to include fees that are paid to that affiliate. The sixth is loan level price adjustments. So this really mainly applies if you're selling to the secondary market. So when you're selling to Fannie and Freddie or other secondary market purchases, they'll pass down loan level price adjustments on you that you, in the end, pass on to the borrower. So if I'm a borrower and I have some dings on my credit, Fannie and Freddie are going to pass down adjustments that'll get passed through to me, the borrower, and it'll generally get passed through either a higher rate or a higher amount of points on my loan. So I might have to pay a half a point because I have dings on my credit. Okay, so we just talked about loan fees that you retain. So the exclusion there generally is fees that you don't retain that are passed through to a third party. They're not included in points and fees. So when you pay for closing services or you pay for an attorney's fee and you don't retain any portion of it, it just passes through, those aren't included. A lot of comments were made on loan level price adjustments to the CFPB saying, well, these should be excluded too because we just pass it through. We're not retaining any of that. Fannie and Freddie's passing it down to us, and we're passing it straight through to the consumer. We're not retaining any bit of it. But they didn't bite on those comments, essentially, and they retained this in there as an inclusion. So LLPAs are included if they're charged as a point or a fee. So we're talking about points and fees. So you could still pass it through to the consumer and not have it included as a point and fee, but you'd have to pass it through to that consumer in the APR. So if you pass through the cost of LLPAs and raise the APR on that consumer, that's not going to affect points and fees at all. If you pass it through as a half of a point, then that half of a point is going to get included in points and fees. And that same concept, that same general rule goes to all points and fees. If you pass it through and account for it in the APR, in the rate, it doesn't get included in points and fees. It only gets included if it's actually charged out to the borrower as a point or a fee. Seventh and last major category of inclusions in points and fees are prepayment penalties. So if you have a prepayment penalty on the loan, that's going to get tacked and rolled into points and fees as well. So you're going to have the maximum penalty that may be charged. Generally, your closed-end loans, that's going to be your inclusion, or the total penalty if the consumer refinances with the current holder of the loan. Those prepayment penalties also get rolled in. So those are your 7 general inclusions in points and fees. Third-party loan originator comp, 1. 2, upfront credit insurance. 3, upfront PMI. 4, bona fide discount points that exceed certain thresholds depending on the APR and average prime offer rate. 5, any fees retained by the bank or the bank's affiliate. 6 loan level price adjustments, and 7 prepayment penalties. Okay, so that's probably the most difficult part of that rule. So if you've stayed with me all the way through here on this webinar, then stick with me. That's probably the hardest, most circuitous part of this rule. So hopefully it'll be smooth sailing here on out, relatively speaking. So we're still on the requirements that are applicable to all QMs, regardless of whether it's a small creditor or eligible loan. So points and fees, the product restrictions, no negative AM interest only. And then for particularly adjustable rate mortgages, there's a certain way that you have to calculate the periodic payment for qualified mortgages. So for your fixed rate loans, there's no magic formula for calculating the periodic payment. It is what it is. Right? It doesn't really change. But for your ARMs, your adjustable rate mortgages, this rule is a new way to calculate that periodic payment. So for QMs, you have to underwrite using a periodic payment that's based on the maximum rate that can apply during the first 5 years after the first regular payment is due. Of course, you also have to take into account your mortgage-related obligations such as taxes and insurance. But you have to underwrite using the max rate in that first 5 years. And, this is key, it's the first 5 years after the first payment is due. So it's not the first 5 years after consummation. It's the first 5 years after that first payment. So that generally be 30 days after consummation is when you start counting. Now that's important because a lot of you likely have 5-1 arms, okay? So your 5-1 arms, as you'll see in some examples we give, you're generally counting the 5 years from consummation. So if you count 5 years out from consummation, that's not going to be 5 years after the first payment is due. You're going to be 30 days short of that date. And so if you have that first adjustment occur 5 years after consummation, then that first adjustment is going to be taken into consideration in calculating the maximum rate. Okay? If you calculate the 5 years from the first payment, then it's not. So let's go through some examples here. So if you have an adjustable rate mortgage, you have an initial fixed rate of 5% for 5 years. You have index plus margin of 6% and 2% annual adjustment cap. So your loan consummates on September 15th, 2014. First monthly payments due November 1st. So your first rate adjustment is going to be set to occur on October 1st of 2019. So as we talked about, that October 1st, that falls within 5 years after the first periodic payment is due. So in this instance, the max rate is going to be the 5% initial fixed rate plus the 2% annual adjustment cap. So you're going to underwrite using a monthly payment based on a 7% APR here. So, I mean, to change this up a little bit, the way you could get, not around this rule, but the way you could work within this rule and have a 5-1 arm and not take that 2% adjustment into account and only underwrite using the 5%, you'd have to push that first adjustment back 30 days. So you'd have to push that first adjustment back to the 61st, or to be really safe, I'd say the 62nd month after consummation. So you go 62 months after consummation. Now, the max rate that can occur within 5 years is just that initial fixed rate of 5%. So that may be something to look at with your 5-1 arms to say, is it worth pushing that out another month or 2 months so that we don't have to underwrite, take into account that first adjustment? Okay. So now your arm with a 3-year discount period, that's going to be, you're clearly going to have to take adjustments into account there. The question will be how many. So if you have 5% rate for 3 years. $200,000 loan, 30-year loan. Adjusts annually after the 3 years, index plus 3% margin, and you have a 2% annual adjustment cap, again, with a 9% lifetime max, okay? So now let's say we consummate on March 15th, first payment due May 1st, so your first rate adjustment is going to occur on April 1st of 2017. Your second is going to be April 1st, 2018. Your third is going to be April 1st, 2019. So you're going to have 3 rate adjustments in this example that occur within the first 5 years. So now you're going to be taking that 5% initial rate, and the max that could potentially occur at any point within the first 5 years is going to be that 5% plus 2 for the first rate adjustment, you're up to 7, plus 2 for the second rate adjustment, you're up to 9, plus 2 for the third rate adjustment, you're up to 11%, okay? So if you had no cap, you'd be underwriting using 11% for a 3-1 arm. A very difficult product, essentially, to market. You have in my example that I put out here, though, there's a 9% cap. So the rate over the 30 years can never go more than 9%. So that bumps it back down to 9. So you were at 11, but you have a 9% cap. So the max that can occur within 5 years is 9. You underwrite using that 9%. So I gave some other examples here you can use about a 5-year and a 7-year. A 7-year, of course, the max that can occur within that, if you have a 7-1 arm, the max that can occur within the first 5 years is going to be the initial fixed rate. So you just use that. Okay, so that's a summary of everything that applies to all qualified mortgages across the board. Your product restrictions, negative AM, interest only, term exceeding 30 years, that applies to all of them. Points and fees restrictions, which we talked about in painstaking detail probably from your perspective, and that way you calculate the payment amount on ARMs. Those 3 items apply whether it's small creditor eligible or standard track qualified mortgages. So now let's go through, visualize that pyramid I had, that inverse pyramid. Let's go through the specifics of some of those exceptions. So your small creditor qualified mortgages. What does it mean to be a small creditor? So the definition is if your bank and any of your affiliates you control originate 500 or fewer first lien closed-end transactions in the preceding calendar year and have total assets of less than $2 billion, then you're a small creditor. So you look at your asset size, first of all. Are you under $2 billion? Okay, you pass that. Then you look at how many closed-end first lien loans did we make in the previous year. Is it less than 500? Okay, then we're a small creditor for this year. Okay? If you're making 1,000 loans a year, it doesn't matter what your asset size is. You're going to be outside of the small creditor exemption. So what this exemption does for you is it exempts you from the 43% DTI cap. So we'll get to standard track QMs. One of the main pieces there is you can't have a standard track QM where the DTI on the loan exceeds 43%. Small creditors can. So you can be a small creditor. You can have whatever debt-to-income ratio you want, and it can still qualify as a small creditor qualified mortgage. So what are the terms that are going to apply for your small creditor QM? Again, those same product restrictions, points and fees, and then the other big restriction is the loan can't be subject to a forward commitment. You have to retain it in portfolio for 3 years. So we'll get to that. Other small creditor underwriting restrictions, you have to consider the monthly payment for mortgage-related obligations. You use that max rate. You consider and verify income and assets and debt. And you consider DTI or residual income. So small creditor loans, you have product restrictions that are here. negative AM, interest only, term, points, and fees. You have underwriting. The underwriting for your small creditor QM is greatly simplified vis-a-vis the standard track QM. So when we talk about standard track, we'll talk about Appendix Q. Appendix Q is a document that's 15 or 20 pages, depending on how you print it, of pretty stringent underwriting criteria. You have to consider income and debt in certain ways. Small creditor underwriting, you still have to consider and verify income and debt, but there is no other detail other than that. Basically, if you're a small creditor, you shouldn't have to make any real underwriting changes on your loans. The only change would be that max rate calculation for your ARMs. You're already considering and verifying income. You're already considering and verifying debt on your loans, right? You're a community bank. Of course you're doing that. You can continue to do that, and you're already considering DTI. You just have to consider them. There's no bright line rules of how you weigh them, how you calculate, how you consider them and weigh them in your underwriting process. You just have to have considered them, and you've already been doing that. So your underwriting changes for small creditors' loans are very, very small, should be. So one way that you would lose QM status, or if you're a small creditor, you may have qualified mortgages that fall outside of that small creditor QM bucket, is if you're selling it off or transferring it within 3 years. So generally for a loan, to get this small creditor QM protection, you have to retain it in portfolio for 3 years. The only way you can transfer it or sell it within 3 years is if you sell it to another small creditor, if it's sold subject to an order from your regulators, which you never want to happen, but if that happens, then it's not going to lose its small creditor QM status. Or if it's sold or transferred as part of a merger or acquisition, it won't lose its small creditor QM status. Otherwise, you have to retain it for 3 years. So if you're selling to Fannie and Freddie, those aren't going to be small creditor QMs. If you're selling to some other secondary market purchaser, those are not going to be small creditor qualified mortgages. They may be qualified mortgages under the eligible loan exception or under standard track, but they won't be small creditor loans. So generally, non-small creditors can't make balloon loans and have them be qualified mortgages. So if you're not a small creditor and you want to make balloon loans, you're looking at ability to repay standard. Okay? If you're a small creditor, however, you can still make balloon loans and have them qualify as qualified mortgages under certain requirements. So the broadest, and this was an amendment they made in May of last year after the rules came out, is if you're a small creditor, regardless of whether you're in a rural or underserved county, you can make loans with a balloon payment and have it be a qualified mortgage for the next 2 years. So basically what the CFPB did here, initially in the January rules, they limited the small creditor balloon exception to small creditors that originate the majority of their loans in rural or underserved counties. Okay? Now, that leaves a lot of small creditors out, right? Anyone that doesn't make a majority in rural or underserved would be out and wouldn't be able to make qualified mortgage balloon loans. So there was a big uproar about that, and the CFPB essentially with this, they conceded that they don't really understand balloon loans that well, and they need to go back and study the use of balloon loans by small creditors and figure out what the need is. So small creditors said, we have a lot of borrowers that need this product, and we don't want to lose that qualified mortgage safe harbor protection. So we want to be able to offer these to our borrowers, but we don't want to take on that added risk that's incumbent with the ability to repay rule. So the CFPB said, okay, we'll give you 2 years at least where you can continue to make those. In those 2 years, the CFPB is expecting to further study the market and figure out what they want to do with it going forward. So you can continue making those balloon loans for 2 years at least. If you are making a majority of your loans in a rural or underserved area, then that is still in the rule. So there's no 2-year expiration on that. So if you're making the majority in a rural or underserved area, unless they change the rules, you should be able to rely on this in your strategic planning and what products you want to offer and say, well, we can continue to do balloons and get QMs. If you're not in a rural or underserved, you continue doing them now, but in 2 years, you're going to have to start planning what you want to do with that product going forward. So again, I laid out here what the actual qualifications are for a balloon loan. Again, those same product and underwriting restrictions, points and fees, products, and your same underwriting criteria that we talked about with the small creditor exemption is going to apply. The CFPB put out a pretty good flow chart for small creditors out on our website. So if you follow this link, it'll go through in a flow chart form what are the requirements for a small creditor loan. There's a lot of detail that's not in the flow chart, of course, otherwise it'd be a pretty cumbersome flow chart, but it's pretty helpful to go through. It's pretty helpful if you are a small creditor to use as a training document to provide out to your lenders and underwriters and say, you know, this is really the process, this is what we're looking for, this is why we've made changes to our policies and procedures, because this is the rule, this is the flow that we're expected to follow now. So that's your small creditor qualified mortgages. Now we're down a level in that inverted pyramid to eligible loans. So eligible loan qualified mortgages are those that are eligible to be purchased by Fannie, Freddie, HUD, the VA, USDA, okay? If they're eligible to be purchased by, and I'll just say Fannie or Freddie for short because they're the most predominant purchaser of community bank loans. If they're eligible to be purchased by Fannie and Freddie, then they can get this temporary eligible loan qualified mortgage status. So what do I mean by temporary? Temporary means this exception expires at the earlier of 2021 or when Fannie, Freddie, or the other agencies adopt their own definition of qualified mortgage. So all of these GSEs are required under Dodd-Frank to adopt their own QM definition. And when they do, then that definition will be used for determining whether or not it's a qualified mortgage. Until that time, what this exception does is it says you can continue selling loans to Fannie and Freddie, making loans that are eligible to be sold to Fannie and Freddie. You can underwrite them in accordance with Fannie and Freddie guidelines, and you'll get that qualified mortgage protection. So if you're currently underwriting in accordance with Fannie and Freddie standards, you shouldn't have to make any major changes to your underwriting procedures to be able to get this eligible loan QM protection. Okay, so when I say eligible, we're talking about eligibility with regard to underwriting, with regard to income, assets, credit history, and debt. If it's not eligible to be purchased by Fannie and Freddie for reasons wholly unrelated to income and debt and ability to repay, you can still take advantage of this eligible loan exception. So that could be, I mean, this wouldn't apply to banks, obviously, but you know, certain creditors Fannie and Freddie won't buy from, but they can still avail themselves of this just if they make loans that meet the Fannie-Freddie underwriting criteria. And if you have any other requirements on the loan, such as that you have to perform after it's sold, the insurance or quality control or servicing, those are not related to underwriting, so they're not going to disqualify a loan from coverage under this exception. So how do you determine whether you're eligible for purchase? If you get that desk underwriter loan prospector print-off that says, yeah, this is approved, this passes Fannie and Freddie's underwriting standards, that's what you use. You can rely on that. So you print that off, and there you go. You have your evidence that this was an eligible loan. You're, of course, going to be liable for the input. You know, if you make mistakes in the terms that you provide to Fannie and Freddie and it really wasn't eligible, that's going to be on you. But you know, if you submit correct information and you get that approval, you get that thumbs up from Fannie and Freddie that it's eligible, then it's an eligible loan. So in sum, so it has to conform to those standards, and you get that approved, eligible, accept, you're going to have an eligible loan. Now, keep in mind those product and points and fees restrictions still apply. So you're still going to have to be, you know, under 3% points and fees and still no negative AM or interest-only loans. Those are the only pieces that Fannie and Freddie have adopted thus far. So Fannie and Freddie have actually, they haven't adopted a qualified mortgage definition for their own purposes yet. What they've adopted is the CFPB's points and fees threshold and their product restrictions, negative AM interest only, 30 years. So they're not going to buy loans that exceed points and fees anymore. Okay, they're not going to buy them at all. But they haven't adopted the qualified mortgage. So they haven't changed their underwriting standards in accordance with Dodd-Frank yet. They're going to have to before 2021 if they still exist. You know, there's legislation out there that wants to completely revamp this structure we have currently of having these GSEs you know, purchase the majority of mortgage loans in the country. So if you have an eligible loan, if you're selling to Fannie and Freddie, just because, you know, it gets pushed back on you, it's not going to be dispositive of the qualified mortgage status. So you could have a loan that gets pushed back on you for reasons wholly unrelated to underwriting, you know, the servicing or quality control. That doesn't mean you're going to necessarily lose your QM status as an eligible loan. Because remember, this is an eligible loan exception. So you don't need to actually sell it. So if you have loans that don't meet the small creditor exemption, but you're still retaining them in portfolio for some period of time, even if you have no intention of selling it to Fannie and Freddie, if you underwrite it in accordance with Fannie and Freddie standards, and if you get that, you know, DU LP approval, then you can retain it and you can take advantage of this eligible loan exception. Okay, so now we're down to standard track qualified mortgages. We're almost done now. So we talked about small creditor, eligible loan, and now we're on to standard track. So these are the loans that aren't small creditor loans, that aren't eligible to be purchased by Fannie or Freddie. Now you're going to have more cumbersome underwriting requirements under the standard track qualified mortgage. So, you know, the high-level summary is, you know, you still have periodic payments, you still have to verify income and assets and debt, you have to consider the debt-to-income ratio, and points and fees and product restrictions still apply. The big difference here is income and assets. So your small creditor exemption, it really just says you have to consider income, assets, and debt. It doesn't say how. Your eligible loan exception, you do what you were doing with Fannie and Freddie, and you continue doing that until Fannie and Freddie changes their requirements. Your standard track qualified mortgage, now you're using Appendix Q. So I have Appendix Q attached. I can provide it out to you, an updated version. It's kind of hard to find in the Federal Register, so I excerpted it. So shoot me an email, give me a call if you can't find it, and I can send you a copy. But Appendix Q lays out in detail, particularly how you calculate income and what you can consider as income and debt. It's based on the HUD handbook. So they took that HUD handbook for making FHA loans, and they adapted it and tweaked it, and they now use that for the standard track qualified mortgage standards. So I have on the next few slides various examples of changes they made after January. So Appendix Q came out with the rule in January, and then they made some tweaks to it in the summer and pulled back some things. And I raise a few of these to highlight, two things. One, that the CFPB has been willing to go back and make adjustments to these rules when there's problems. So, continue to make comments to the CFPB even after the rulemaking process. Two, I think some of these items are just good ways to highlight how Appendix Q works and how it's different from ability to repay, how it's different from the small creditor exemption. So one is stability of income. So Appendix Q is very detailed about how you consider income. Initially when it came out, one item they had in there was that you actually had to determine the consumer's qualifications for their job and examine and inquire with the employer that the consumer that the employer expects the consumer to continue to be employed. Okay? That is incredibly cumbersome and probably impossible, right? You're a bank. How are you, you're not a human resource expert. How are you supposed to know whether an engineer and an attorney and a pediatrician are all qualified for their position and have the training required? And how are you ever going to get an employer to tell you that, yes, Jeff, we expect him to continue to be employed? They're not going to make a statement like that and put themselves out there. So they pulled back on that, and they said, all right, you don't have to do that anymore. All you have to do is get a verification of current employment. So you get a verification that from the employer that the borrower is currently employed. There's no statement required about whether they're going to get fired tomorrow or next year. It's just, are they currently employed? And you can rely on that. Okay? So that shows that they made a change, they pulled back on something, but it also shows the level of detail of underwriting that's required here. So within the income requirement, you have to consider things like if they're self-employed, they have to be able to have 2 years. You have to, when you're considering bonuses or commissions, you have to count them a certain way, have a certain history of bonuses, and be able to show that it's not on the decline. So there's a lot of detail to unpack in how you calculate income under Appendix Q. So overtime and bonus. So initially you had to determine whether it was likely, whether it would continue. Now the new requirement is that you can use bonus income if the consumer has received it for the past 2 years and nothing indicates that it's likely to cease. So you have that verification of employment from the borrower, from the borrower's employer, I should say, and you don't have any knowledge that it's likely to cease, like they've changed their job role at the employer into a non-commissioned position, right? If you know that, then you shouldn't be considering bonus. But if they're in that same position, you just look at the 2-year history. So keep in mind, all of this detail, these are ways that you can get kicked out of the qualified mortgage protection and into ability to repay. So if you have over 43% DTI, of course, you're out of qualified mortgages. But also if you just can't underwrite the loan in accordance with Appendix Q. So if you have somebody that's heavily relying on bonus income, but they only have 1 year of bonus income history, if they need that to be able to get the loan, they're not going to be able to get a qualified mortgage. You're not going to be able to make it a QM. They only have 1 year. You have to consider 2 years. So you can make that loan, but now you're outside of qualified mortgages and you're in the ability to repay bucket. You're into that rebuttable presumption, unless you can make it an eligible loan or a small creditor loan where the underwriting is a bit less stringent. Social Security income they pulled back on initially. Again, you had to get proof of continuation of payments. Now you can just rely on that Social Security benefits letter of their current benefits. This one I threw in just because, generally, I certainly don't agree with all regulations, far from it. But generally, I can see the purpose of it and can at least understand where the regulator is coming from. I may not agree with it, but I can understand it. This one I still don't understand. So initially, the rule said you can't consider rental income from a borrower. So if a borrower has someone renting, their basement, you can't consider that rental income if the renter isn't related to the borrower by blood, marriage, or law. What the heck? What's the reason of that? Who cares if they're related or not? It's income, right? $1's not worth more if it's paid by your brother as opposed to paid by somebody you're not related to. If anything, it's probably worth less if it's paid by some people's brothers. So they pulled back on that and said, no, it doesn't matter whether they're related or not. That's not a major point, but it's just kind of an interesting one, I thought, that I never really understood. So, again, 43% DTI, that's the bright line debt-to-income ratio for standard track qualified mortgages. So if you're selling to Fannie or Freddie and they'll buy a loan that's over 43% DTI, fine. It's an eligible loan QM. Small creditor, if you feel that your community need and you can make loans and have sound underwriting for a 50 or 60, whatever it may be, DTI, you can do that, and you're still going to get a QM. Once you're outside of those exceptions, though, and you want to make a qualified mortgage and get that safe harbor, it can't be above 43%. That's going to kick you down to the ability to repay. Okay? So hopefully this was helpful. We're going to have a couple more in the series focused on the ability to repay rule. It's just, there's a lot to unpack with this rule. So today I focused on qualified mortgages, your small creditor, eligible loan exceptions, your standard track mortgages, and then points and fees and some of those items that apply across the board to all QMs. I'll do another webinar that you can find out there on the ability to repay standard. So if after listening to today's presentation you say, well, wait a minute, we got loans that aren't going to fall within any of those. They're not going to be a small creditor loan, an eligible loan, and it's over 43% DTI. It's not going to be a standard track loan. Well, all right, you can still make those loans, but you're going to have to listen to the next webinar we do on the ability to repay rule. So now you're going to be subject to that rule and have to follow that to get the rebuttable presumption of compliance with this rule. Then on a third in the series, we're going to talk about, safe harbors versus rebuttable presumptions. In litigation, what's the difference between the risks there? What other risks are associated with these rules? Is it be fair lending or secondary market risks? So we'll talk about some of those things that can play into your decision-making as you make decisions on products that you want to make and then continue to reevaluate those decisions over the years as the market begins to crystallize, frankly. I mean, all of these rules are new to everybody. And so it's going to take some time before we can get a picture of what the risks really are. What are plaintiffs suing over? How are they doing it? What are judges considering? What are the courts considering? How's it working? We'll talk a bit about that on that third webinar on ATR QM risks. So if you have any questions or need anything, feel free to contact me, Jay Anderson at Dickinson Law, or 515-246-4515. Thank you.